Welcome to another episode of the Force Podcast. I am FIBA CEO and President David Schwartz.
Hello, everyone. Welcome to another episode of the FIBA on Risk and Compliance Excellence, the Force Podcast. Today's topic, fair access laws. So these laws have been framed as part of an anti-ESG or anti-debanking movement. At the recent Davos World Economic Forum, President Trump pointed out and told Bank of America CEO Brian Moynihan during the Q&A session, "You've done a fantastic job, but I hope you start opening your bank to conservatives, because many conservatives complain that the banks are not allowing them to do business within the bank." And that included a place called Bank of America. They don't take conservative business. You and JP Morgan CEO Jamie Dimon and everybody, I hope you are going to open your banks to conservatives, because what you're doing is wrong. Further to that, the acting chairman of the FDIC, Travis Hill, had issued a statement that included a list of matters that he expected the FDIC to focus on in this coming months. One of those topics was, quote, work to ensure law-abiding citizens, law-abiding customers have and do not lose access to bank accounts and banking services. So today, we're going to discuss this trend with Marina Olman-Pal, co-chair of Greenberg Traurig's Financial Regulatory and Compliance Practice, and Carl Fornaris, co-chair of the Financial Services Practice at Winston Strawn. Marina, Carl, thank you for joining us.
Thank you, David.
So I like to say, and I know you've all heard me say this before, that we in Florida are the poster child for these types of laws. We've seen in recent years, and we'll discuss this in a little more detail, a couple of bills that went through the House focused on these subjects, on giving fair access to everyone, and setting up a complaint process with the state regulator if somebody felt that they had been debanked or denied service. Recently, this past session, and we're waiting to see if the governor will sign it, which most likely he will, that went even further and was made more specific for the agricultural industry, for agricultural businesses. But this went even further in giving them a private right of action to sue the financial institution. So that's a little concerning. And then at the federal level, of course, there is the Fair Access to Banking Act, which is still moving around Congress, and this year probably has a better chance than it has in the past of passing. So, Marina, Carl, at our recent anti-money laundering conference, you both participated, Carl as moderator and Marina as one of the panelists, on a very interesting panel on this topic, together with a representative from our Florida Office of Financial Regulation. But for those who missed it, perhaps you could both provide us a summary of that discussion.
Sure, and I'm happy to get started if that's okay with you, Carl. So yes, that's absolutely right, David. You know, we had an important discussion on federal and state law developments with respect to fair access, particularly focusing on the Florida Fair Access Law, the OFR's implementation and experience with the Fair Access Law currently. We heard from Ben Brinkley, the new director at the Division of Financial Institutions. We also heard from Wayne Shaw, who works very closely in the Caribbean region and has been working with a number of banks who have been locally subject to fair access laws. And so we heard his viewpoint. And Carl actually presented on the federal fair access law developments. I'm happy to cover and I think summarize a few of the key points that Ben Brinkley highlighted while he was speaking, on behalf of the OFR in terms of what they've been seeing so far, what are some of the best practices. I think we had some very helpful take-home points for our members and for the audience that I think are probably good to repeat on this podcast. So if that's okay with you, I'll just go over a few of them.
Please.
Thank you. In terms of complaints, so as everybody knows, right, our Florida Fair Access Law provides for a customer complaint process. We've had this for almost a year now, where if the customer believes that the bank acted in a way in which it's unsafe and unsound or in violation of the Florida Fair Access Statute, it can actually file a complaint against the bank, which the OFR would review, investigate, and then make a determination with respect to whether a violation has been found. In almost a year, Ben Brinkley, again, on behalf of the OFR, noted that the OFR has not seen a large number of complaints. In fact, I believe he said that the total number at the time that we had the panel was probably less than 10. And I think that it could even be something that he could count in one hand as well. So they have not seen a large number of complaints, but they have seen complaints being filed by customers. They are currently in the investigative process. He has noted that the investigative process includes not only reviewing the complaint that the customer provides and the response that the financial institution would file in connection with that complaint, but also interviews with both parties and discussions with both parties as part of the complaint investigation process, which was new to us, as that is not included in the statute. And so those were very helpful points to keep in mind. He also noted, it's a question that I'm sure, Carl, you also get quite often, in connection with complaints and the OFR determinations. One of the questions that we get is whether these are made publicly available once the investigation is closed. The OFR confirmed that where there is a determination that there was no violation, both the complaint and the OFR determination is made public. And so, anyone could essentially get access to that information. But with respect to investigations for where a violation is found, those reports are actually just sent to the Florida AG for enforcement. He also noted something very important, and another question that we often get from banks in connection with complaints that involve a termination or denial that relates to a BSA AML matter. He noted that the OFR and financial institutions are mindful and should be mindful of conflict of law issues. And so when a bank is responding to a complaint that involves closure, denial, etc., related to a BSA AML matter, particularly if it's confidential, such as a SAR, the response should actually be very broad and high level without sharing any confidential information. And it should include a phone number where the OFR could call the institution or the appropriate person at the institution to obtain additional information. The discussion there, or the thinking there, is that we don't want to have the bank put information, confidential information, in writing. That again, could raise issues, and so the investigation would essentially be done primarily verbally. In terms of attestations, the OFR noted, and this is new, and actually one thing that I wanted to point out. I think the importance of this panel, of course, is to get an update on fair access and the OFR implementation, but I think it's even more important because of the fact that we've had change in senior staff at the OFR. And so we are seeing a little bit of a change in terms of what they're looking for, what their expectations are, their messaging as well. So the OFR noted that, whereas I think, before we had heard that the attestations, at least initially, were being just received and, once they were submitted, it appears that now they're actually reviewing those attestations that were submitted. And so that's something to keep in mind. Ben Brinkley also went over a few best practices, which I thought were also very helpful, some of which we have been discussing. but others that I think are good to also repeat even one more time. So in connection with decision making on, again, denials, terminations, as we've always said, documentation is very important. Making sure that that documentation shows how the bank is managing risk and how it's making its decisions, and what the process is for denials. One key addition that he had or note that he had is that a lot of banks, and one of the things that the OFR is viewing very positively is having an audit or a secondary review process for when there's a denial of service or termination to ensure compliance with fair access. So those are some of the highlights and notes that I had from Ben Brinkley's panel, which I thought was very helpful. I don't know, Carl, if you have anything to add to that, or if you want to cover the federal component.
No, I think you covered the Florida component very well and in considerable detail. I would add simply that Florida took the lead here amongst other states, right? Like Texas, which had some efforts, Tennessee, more of a Florida type effort, but Florida's was really the first, and the way that the Florida legislature aggressively took steps to make it become law in 2023, and then to refine it and make it more forceful in 2024, right, with the complaint process that you were talking about, shows that it's fair access or de-risking or debanking, whatever you want to call it, is a major state legislative priority item. And we have seen that other states, about a dozen or so, close to a dozen, have bills percolating to try to follow Florida or Tennessee. But on the federal side, I think the best way to look at the federal side is what the OCC initially did at the tail end of Trump 1.0. So this would have been around the end of 2020, when the Trump administration back then, through the OCC, put out a fair access rule that would have applied to national banks and federal savings associations. And with Biden, winning the White House very quickly in January of 2021, it might have been February of 2021. The incoming Biden administration put the brakes on the effectiveness of that rule. They caused that it never made it to the Federal Register. But this sort of template was floating out there, and it became the inspiration for a couple of bills on the Hill that are even more forceful than the OCC proposal. And I'll talk about those two. But behind it all, on the federal level, is this impetus coming from the White House to get digital assets firms banked more broadly than now. So digital asset firms, crypto companies, digital asset exchangers, they are viewed as a higher risk industry, and by some a high risk industry. Whether that's fair or not, that's how many banks view them. And so many banks have not given them service, which has hurt the industry, hurt its growth. And so the Trump administration, which, as many people know, has been very, very favorable toward the crypto industry, has made as one of its tenets the push for debanking laws. And so that's why we see this sudden flurry of legislative activity coming out. Now, whether it will become law is a huge if, especially after what we saw, I think it was at the end of last week, with the Senate Democratic caucus, sort of putting the brakes on the Genius Act, in a sort of a show of solidarity on the Democratic side of the aisle, to push back against certain efforts of the Trump administration of Trump 2.0. So whether we're going to see this federal proposed legislation become law, I think it's, like I said, I think it's a huge if. And if it doesn't happen this year, I don't see it happening at all next year, because next year is an election year. We have very tight races for an extremely narrow Republican majority at the House and a relatively narrow majority at the Senate. So I just don't see this legislation, financial services legislation, happening in 2026 if it doesn't happen in 2025. So if it does happen this year, let's talk about the two two core bills. The first one is the FIRM Act, FIRM, which is a Financial Integrity and Regulation Management Act. And basically, that one, in a way, is kind of become moot, and I'll explain why in a second. But what that one basically says is that the federal financial services agencies cannot take any actions where they are judging, they're examining institutions on the basis of reputation risk. And the bill defines reputation risk as a potential that negative publicity or negative public opinion regarding an institution's business practices, whether true or not, will cause a decline in confidence in the institution or a decline in the customer base, blah, blah, blah. And that comes out of many large institutions following the lead in Operation Choke Point from the Obama administration not to provide, for example, credit facilities or other financial products and services to, for example, fossil fuel industries, coal companies, firearms manufacturers, etc. And so the push here with this bill is to gut reputation risk from the lexicon of the federal banking agencies. I say it's kind of moot because all three of the federal banking agencies, either formally or through testimony, have made statements that reputation risk is being deleted from their examination manuals. So that is the FIRM Act. But the other big one, which is much more reminiscent of the Florida law that Marina was talking about, is the Fair Access to Banking Act, which was initially introduced by Congressman out of Kentucky, Republican Andy Barr, and through the Financial Services Committee. That's HR 2743. And more recently, it was resurrected by Senator Kramer. And there's a companion bill at the House as well. And I'll just briefly describe what it does, but that has like a 1-2 punch to it. Okay, this Fair Access to Banking Act. First of all, there's one big punch against the large money center banks. And what it basically says is if you are a bank that has $100 million or more in assets and you violate Section 8 of this Fair Access to Banking Act, and Section 8 is titled Fair Access to Financial Services, and it kind of follows the Florida model, right? Which is that you cannot either turn away customer business, new customers. You cannot decline existing customers for any type of product or service, deposit, credit, etc. If the denial is based on a reason that is not quantitative, impartial, or risk-based, and it's very sweeping. Financial service means commercial and merchant banking, lending, financing, leasing, investment advisory, credit card services, payment processing, insurance products. So it's really everything under a financial services umbrella. And so if that denial is on a basis similar to to the reasons that Florida articulates are impermissible, okay, those banks will be stripped of two things. One, their ability to access the Fed discount window. Okay, so their ability to borrow from the Fed, that's huge. And second, access to ACH networks. That's also huge. Okay, so it's a real big deterrent. Again, this is a proposed federal bill. Also for credit card networks, regardless of size. So that's all the major credit card networks. Same standard that if they violate Section 8, they will not have access to banking services. So very powerful there. The main, I think, part of the bill is that that's a private right of action to a who is denied service. So what is a private right of action? That means the right of an individual, a consumer, to file a lawsuit, irregardless of what the terms and conditions in their customer agreement says. So the customer agreement that you might have with your bank might say, we can close your account for any reason or no reason, at any time, with or without notice, and you can't do anything about it. That's what the contract can say. What the bill says, and if it becomes law, what the statute would say, is that a person can file a civil lawsuit in federal court against a bank or credit union that violates Section 8. They don't have to go through any federal agency. They can just run straight to court. And here's the real fangs to this, is that if the person prevails, they get reasonable attorney's fees and treble damages, which is triple damages. So a lot going on the federal level. Again, all in bill form. It's not law, but things to keep in mind. I'll turn it back to you, David.
Thanks, Carl. And yes, it'll be interesting to see if that does make it through, because that could bring up some more interesting challenges, but I think challenges that we may already have. So Marina, Carl, alluded to the fact that other states have passed similar laws, but do they rise to the level of what we have in Florida? I like to tell the story. Several years ago at our AML conference, we had the U.S. Attorney for the Southern District of Florida do the keynote, and he stepped up to the podium and he welcomed everybody, because typically about 30% of our audience is from Latin America and the Caribbean. He said, I want to welcome you all to Florida and let you know that we are number one in healthcare fraud, in Medicare fraud, in tax fraud. And he just kept ticking them off. And I'm looking at him and saying, listen, we want to invite people and expect them to come. You're not somebody that represents the Tourism Bureau, obviously. But it's true. And I think these types of laws, we are the poster child. But what do they look like in other states? Do they rise to the level of Florida?
So I can add some commentary on that. So, Carl mentioned a dozen or so other states that have introduced laws. Tennessee passed a fair access law last year. So there are differences, even in some of the bills that were introduced in this last session. A number of these states are really focusing, like the federal bill, they're focusing on the larger institutions, so 100 billion in assets or more. Florida does not make that distinction. In fact, Florida is incredibly aggressive, David, as you know. It has no distinction in terms of size. It applies essentially to any financial institution, which could be, a Florida state chartered bank. It could be an out-of-state chartered bank. It could be a nationally chartered bank that has operations in the state of Florida, that has customers in Florida. One of the issues that we've had with our fair access bill is the fact that it doesn't provide clarity as to its reach. So whether let's say a non, Florida chartered bank that has customers in the state but does not have physical presence, does that bank need to comply with Florida fair access law? There's lack of clarity there, unfortunately. That's one question, in fact, that was presented to Ben Brinkley during the Q&A session. You may recall, David, that you gave extra time for that. And Ben Brinkley responded to that effect that, and I'm going to read from my notes, that if an out-of-state charter bank, so non-Florida charter bank, does quote-unquote business in the state, then it's probably applicable. The problem is that we don't really have a definition for what qualifies as really doing business in the state of Florida. There's some guidance as to what kind of activity does not qualify as doing business in the state. So oftentimes we look at that for our clients. I think the view that we've taken mostly in Florida is that if you have a physical office, physical operations in the state, then you should be complying with the attestation requirements and the law. But again, if going back to other states, it really varies from state to state. We have seen a number of other states include private right of action language in their bills. Tennessee, I believe, has a private right of action component to it. Luckily, we were able to get rid of that here in Florida, but hey, look at the ag bill, right? That now has a private right of action. And so I think, when we're looking at the states, so while at the federal level, action may be delayed, the states are definitely moving and continuing to move with respect to these issues. And I think it's something that financial institutions should be tracking and either already complying if it's, already applicable to them, or getting ready to comply with the requirements. It's coming, and in my view, at least, it's, if you are in a larger financial institution, so, again, $100 billion in assets or more, something definitely that, should be getting looked at, and even for smaller institutions. And one of the other things that I would add is that it's not even just, complying with the legislation and looking at bills and monitoring for developments, but also the fact that these laws are now creating certain expectations in the public. We are seeing increased litigation in connection with fair access claims. Trump sued Capital One, right? And we've seen other initiatives. And so even if it's not coming from law or regulatory expectations, it may be coming from the public. And so there's litigation risk as well.
I think some of the good news is, and you mentioned it earlier, the respect for the Bank Secrecy Act, particularly if a SAR was filed. And in the agriculture bill that was just passed this year, there is actually a provision in there that does state that if the financial institution, it doesn't mention a SAR, but suspicious activity or risk is really what it bases it on, that can be the out for a financial institution. So it comes back to what you were saying, that there needs to be a process for reviewing these closures or denials of service, well documented, just like with anything else. I mean, we're always telling them, right? Document. And particularly in these cases, and sure, it's more work. It may require either reallocation of resources or additional resources. But now that private right of action issue, and you're right, there's a Capital One lawsuit out there, you don't want to fall into that trap. Carl, one of the things, and I had a call today with one of our federal functional regulators, and we were discussing this issue, particularly now that we have the agriculture bill. And they raised the question of federal preemption, which I thought was very interesting. Maybe you could, briefly explain what they mean by that and how it would be applicable.
Yeah, so federal preemption is the notion that the U.S. Constitution and all federal laws thereunder are the supreme law of the land, and they act to preempt or make ineffective a state law that is inconsistent with the federal law. In the context of debanking, I'm just not terribly sure from a legal perspective how helpful federal preemption principles are with respect to national banks. The OCC, under the prior administration, wrote a letter at the behest of congressional delegation on the Democratic side to the state of Florida, basically saying that the Florida legislation might be problematic from a federal preemption perspective. Of course, the OCC didn't take an actual preemption determination because they know that it's not clear. Dodd-Frank Act in 2010 watered down notions of federal preemption in favor of national banks. It used to be before 2010 that federal preemption was a real sword in the hands of a national bank because the OCC stood right behind the national banks and their operating subsidiaries. That's been very much watered down. It's got to really be if there is a state consumer protection law, and arguably, debanking is state consumer protection legislation. There has to be an analysis done as to why there is inconsistency and how the state law is materially interfering with the operations of the national bank. And so judicially, the question hasn't been tested in the context of the Florida legislation or the Tennessee legislation. And it's a coin flip, perhaps, as to whether it would be a way for national banks to get out of these types of state laws. It still doesn't help state chartered banks that don't have a physical operation in Florida but are operating in the state of Florida. And I want to touch on that in a second. And it doesn't help non-U.S. banks that operate branches and agencies perhaps in New York, but are active in Florida or Tennessee. So preemption is only helpful for national banks, federal savings associations, and federal branches of non-U.S. banks. There's still an entire category of state licensed entities that wouldn't get the benefit of that. I think that's one observation. The other observation, Marina was talking about how the Florida law uses a definition of financial institution, and the definition of financial institution is under the statute very broad. It literally picks up every type of federal or state licensed institution. What the face of the not clear on is whether an out-of-state bank with no operations, right, is picked up. And Marina explained what one OFR person, OFR staffer, the press release that accompanied the 2024 amendments stated that the Florida law, the Florida debanking law, applied to non-Florida banks, quote unquote, operating in Florida. Whatever that means. What does operating in Florida mean, right? What OFR staff said? What does doing business in Florida? What does that mean? And it has to, if you're one of these institutions, you have to think about it carefully, because you are a consumer complaint away. You are a Florida AG office investigation away from it being looked at. Right, the determination to not provide services to a Florida-located enterprise or a Florida-located consumer, and the irony is that Florida is I believe, the only state of the union whose constitution codifies, and it happened, I think, in 2017 or 2018. It codifies a Chevron, anti-Chevron standard, right? That it basically says that administrative agencies get no deference on interpreting a Florida state statute. And yet, here we are, right, 7-8 years later, and we have an agency that has been thrust into these very difficult determinations because the legislature didn't make clear exactly how non-Florida institutions that don't have a physical presence in the state should be treated. So a lot of questions, all, very interesting stuff, but from the perspective of these institutions, that are possibly under the net, they have to look at it carefully and seriously.
So, Marina, you mentioned it, so I'm going to have to follow up on it. So while we don't have a private right of action here, and there are many states that don't have one. So we have the Trump family suing Capital One. We've had others do the same. On what basis are they doing this? I know that there was recently, I don't know if it was just a comment from somebody involved in the action or where I saw this, but basically the question came up as to, okay, so they're suing Capital One on what basis? What are they claiming is the basis? And maybe not what is the likelihood of the outcome, but can this really move forward? I hate to put you on the spot, but you did raise the question. I think it's an important one, particularly here in the state of Florida, now that this agriculture bill is going to be signed, because in that call I had with that regulator today, one of the things that did come up was, well, agriculture, that's kind of a broad definition, and there is a broad definition that can be raised that can include businesses that weren't not thinking about it. It's just related to, the orange crops, etc. How about marijuana? How about other related items like that? So, can somebody just walk in and sue on those bases?
And so we've been seeing with respect to these lawsuits, citations to, and the Trump lawsuit did have a reference to the House Bill 989 component, but it didn't apply for the times in which the activities were taking place. But there's reference to state consumer lending laws, state consumer protection laws. We'll see how this is determined and how it comes out. But right now, that's what we're seeing in terms of these claims being filed.
So it sounds like what my civil procedure professor told us in law school. You just throw everything against the wall and hope and see what sticks. That's in right. The case of your pleadings. Carl's nodding his head because that could be the Carl strategy too. If you're going to the mattresses, as my New York civil procedure professor used to say, you pull out everything. You pull out everything you have, and that's right. And that's what they've done.
Yeah, and in those states where it works, it creates precedent for it, right?
Yes, and but the question, Carl, coming back to the federal, if it would pass, let's do the hypothetical. If the federal law would come into being, what happens to all these state laws? What happens to House Bill 989, Senate Bill 700 in the state of Florida?
Well, if these federal laws are passed, I think that they will, they'll certainly have their own standards, creating possibly that federal private right of action, and they will exist independent of these growing, Florida and other state law, whether it's a private right of action or an administrative complaint process. The so-called red states and blue states, right? You might see more of these red states have these copycat statutes because it's a very politically charged issue. This goes back, David, to 2006, 2007, and the whole concept of de-risking, right? Of entire categories of customers being shut off and customers getting a letter in the mail saying, Yeah, we're sorry. We're closing your account. We're sending you a cashier's check in 30 days. Thank you very much.
Yeah, but didn't banks do that? Because, and you mentioned choke point earlier, didn't banks do that because you had examiners walking in your institution and asking questions or framing questions in such a way that the bank started to wonder, is this something that I should be doing? Particularly here in South Florida, that came up with correspondent banking. An examiner would walk in and say, "Oh, and this happened in one of the financial institutions I worked in. Oh, you're banking banks from Ecuador. Ah, interesting. Oh, you have those offshore corporations, the private investment companies. Hmm, interesting." Which makes a bank think, is there something wrong with that? Should I be banking it? And then they started to go down that road. And then, of course, Choke Point really put it out
Exactly. I'll never forget it. Early on, this is the starting point of all this was Riggs Bank and the investigation by the Permanent Subcommittee on Investigations of the U.S. Senate, but back then run by the late Senator Carl Levin, that they did an investigation on the OCC's handling of then Riggs Bank's a private banking business, particularly their embassy business and their private wealth business, as to certain heads of state and former heads of state and their family members. And the funny thing was is that what that particular bank was doing, they were doing it all under pre-Patriot Act, pre-2001 law, when there basically was no law on enhanced due diligence. But the Senate, the subcommittee used a pair of 2001 lens to take and legal standards to look at conduct from the late 90s and what the regulator did or didn't do, and then that gets published, and sort of the rest is history, right? From there, the OCC and then eventually the other federal agencies follow suit. They come with harsher and harsher and harsher civil money penalties, which back in the quote unquote old days was maybe a couple $100,000, and then you started to see tens of millions, hundreds of millions, deferred prosecution agreements. We recently saw a large money center bank in October of 2024 get enter into a plea agreement for allegedly conspiring to fail to implement an effective AML program. And so that's this, we've gotten to this crescendo of this hyper enforcement in AML. And now for the first time since 2005, and this is all over the last 90 days, we're seeing this attempt to roll back this heavy-handed form of regulation and enforcement. And we've heard in the news the mandate coming out of the White House, trickling down to the federal banking agencies and even other agencies about deregulation. You've seen, we talked about this on this podcast about how de-risking. We're seeing that specific mandate, right, for any significant uh, uh, regulatory policy that's being taken has to be run up to the White House. So what for many years, right, was a very decentralized federal administrative bureaucracy, there is now a concerted effort to reshape that decentralized bureaucracy into a very centralized, very streamlined set of actors and decision makers that basically are rolling up to the Treasury Department and then from there up to the White House, and real decisions have to be vetted by people at the White House. So it's a type of accountability that we just haven't seen before. So a lot of changes over the last 90 days. How it trickles down, we will see. But David, I think we were talking about this a little earlier, right before the podcast, how the CFPB today released a statement that it is rescinding 30 federal guidances and statements that they had put out. And so I think we're going to see the same thing because there's a mandate from the other federal agencies as well. And I think that whole concept of debanking, de-risking will be on the agenda as well.
Well,
And
Marina and I, in our
I-
recent visit to Washington, we heard some good news that came out of the House, basically in a meeting that we had, where we were told, well, don't worry, we're not targeting you, the banks, we're actually targeting the regulators, which I thought was a very interesting comment. We're close to running out of time, so I want to see if we can just briefly get from the two of you, what are you advising your financial institution clients on how to deal with these laws? I won't even say how to comply with them. It's really, how do you manage it? Just briefly, what are you advising them, Marina?
Sure. And just before I get to that, I just wanted to add one component because I want to make sure we don't miss it when we're having these discussions. I know a lot of these laws appear to focus and do focus on de-risking, debanking, but there's also a fair access component. And I will say that is something Carl Fornaris that the Democratic Party does support. We've seen support from Senator Warren, right? We've seen, statements made by, Chopra, right, at the CFPB. So I do think that there is bipartisan appetite for this. I do think this is something that will happen eventually. I do think the administration has its own priorities. Regulation is a big one. But I think that there's certain topics and issues that are of importance to the new administration. And I think fair access is one of them. In my view, I think, if it's not this year, maybe next year, we should be seeing something. In the meantime, what we are advising our financial institution clients is to continue to monitor federal and state developments, make sure that they develop a strategy, particularly at the state level, where lobbying may be necessary in connection with these bills. There are components which are very concerning. And so that's something definitely to look at. Also engage, internally with the board and other key decision makers within these institutions. Look at policies, procedures, see whether any changes need to be made, and start having those discussions to prepare for coming into compliance with, again, not only, debanking, but also being sure of, covering the fair access component of these laws.
Carl, she took a little political shot there. I'm not sure.
Yeah, I know. Wow.
Right across the bow too. It wasn't subtle. It was
That's
direct.
okay.
So, what are you advising your clients?
So look, I think those are all good points, particularly the lobbying advice about hiring lobbyists at the state level, particularly because to sit on the sidelines and do nothing and just say, "Oh my, this is going to be terrible." It's just it becomes a fait accompli. So I think the lobbying is important. But I would just echo what Marina said: is look at your internal policies and procedures, look at statements that might contain something that might have been drafted over the last, certainly before 2025, but that might have been drafted particularly, when we started to see this growth in ESG principles, because that is what this legislation is targeting. This is anti-ESG legislation, broadly defined, and look for statements in your policies and procedures and comb through them. And now's the time to edit them, even if you're not an institution that is active in Florida or Tennessee. It could be a matter of time before other states pass their bills, and it's good to stay ahead of the curve. Or there could be an institution where you think you're not active in these states, and somehow you get a lawsuit out of the blue from one of these states, and so I think it's just good practice to look at what statements you have and make very thoughtful decisions about whether to keep language in regarding the types of customers you will bank, but more particularly the types of customers that you're not going to bank, and look at those and see if that bears, some amelioration.
Great. Well, time has run out. It always seems to go very quickly. So I want to thank you both for sharing those perspectives with our audience. One of those key points is definitely the advocacy side. Not that it's always successful. I think when House Bill 3 here in Florida came, it was just a steamroller. There was no stopping it. It didn't matter what you did. As Marina mentioned earlier, when it came to the next step with House Bill 989, we were able, and we were very successful at getting that private right of action removed. Fast forward to this year in the agricultural bill, Senate Bill 700, there was no stopping that private right of action. So it's interesting how it does change from year to year, from legislative session to session. But I think the takeaway is you never give up. You have to keep trying to push it because, and this was mentioned earlier when Carl was talking about the federal bill, there's a limited window there, right? Things could change at the midterms and then it's not going to happen. So be aware, be awake, keep your eyes on this. When you're not sure what you should be doing, talk to your legal counsel, because as you heard from our two great legal counsels here, they are very up on all of it. So thank you all for joining us. I hope you had some good takeaways here. You should have. If you have any questions, you can always reach out. Particularly here in Miami, we're a small community, even though we're a big community and everybody knows everybody. So reach out, always ask, don't be afraid, because you don't want to be the one caught in the trap. And watch out for future Force podcasts. We'll be covering several other important topics. And we also have local events that you might want to attend, maybe even one upcoming where the Florida OFR will be present, and you can ask some of those questions. So keep your eye on our social media, on our emails, and we'll see you all again soon. Thanks for watching.
Thank you.
Thank you for joining us in this new episode of The Force. Write to us at marketingfiba@fiba.net and send us the topics you would like us to cover in our next episodes. For more information on the benefits and value of being a FIBA member, visit us at www.fiba.net.